Okay, I apologize. The IT folks are going to be coming into my chambers in a second, but let's start this. Maybe I'll be able to join at some point by my computer. Joe, could you call the roll, please?
Yes, Your Honor. Your Honor is here. Judge Armada.
Present.
Judge Chaplin.
Here.
Judge Green.
Present.
Judge Maturowski.
Present.
Judge McLaughlin.
Here.
Judge Pearson.
Present.
Judge Prats.
Here.
Judge Stewart.
Okay, thanks.
Sorry, here.
That's everyone, Your Honor.
Thank you very much, and please bear with me while I'm holding my phone. The first item on our agenda is the approval of the minutes from the November 27th meeting. Is there a motion to approve?
So moved.
Is there a second?
Second.
Is there any discussions or modifications to the minutes? If not, all in favor, please raise your hand. Opposed? I can't see everybody, so I'm assuming that was unanimous. Joe, if you see something to the contrary, please let me know.
Justice McDonald, I'm just going to abstain. It's Judge McLaughlin. I wasn't present at the last board meeting, the committee meeting.
Thank you very much. Okay, the next item on our agenda then is 2021-027, a proposal to amend the practice book to include uniform standard interrogatories and production requests for tax appeals. I understand we're going to have an update, Attorney Del Campo.
Yes, Your Honor. This was on in October, and it was tabled until today. And there's an ad hoc committee that's been working on trying to reach a consensus proposal. Attorney Servo Didio is here, and several others from the ad hoc committee. I'm not exactly sure who wants to speak, but he did assure me that someone would update the committee.
Why don't we start with Attorney Servadidio? I'm sure he knows who else might want to speak.
Thank you, Justice McDonald. And I think most of the other committee members are present and are certainly welcome to participate. Since the last update to the committee at the end of October, our ad hoc committee of 6 attorneys, 3 who focus primarily on taxpayer representation, 3 on municipal representation, have had a series of meetings and have exchanged drafts with regard to discovery directed at both taxpayers and municipalities. There have been a lot of policy discussions, and I'm pleased to say I think we've worked through essentially, with maybe a couple or 3 exceptions, have worked through those issues and have exchanged a set of redlined documents which we're just awaiting one side of the committee to react to. I anticipate maybe one more meeting of the group, and then I'm hoping we can present a consensus set of requests to the committee for its consideration.
Okay, I appreciate that. I'm sorry, Attorney Servadidio, did anybody else from the committee want to address the committee?
Not that I'm aware of, but if anybody else from the group wants to click on, I guess this would be the time.
Otherwise, we'll accept Attorney Servadidio's update, which is appreciated. Do any members of the committee have any questions on this item? If not, we will move on to the next item with our gratitude to all of the members of the committee. Next is item 2023-006, a proposal to create hybrid files upon request in cases filed on or before 2014. It looks like I'm coming online here. Hold on. I'm switch over.
Yeah, do that. If I can hear you.
Can you hear me? Okay. So next then is the proposal to create hybrid files. And we have some comments from the Judicial Branch Court Operations. Attorney Del Campo.
Yes, Your Honor. That was last time in November. Judges Bellis, Albus, and Diana had submitted this to the advisory committee on e-filing. And after they did that, they were.
I can't hear you. This is unbelievable.
sorry.
Let me try this again. Sorry, guys. All right, I'm back on my phone. This is not how the highest court of the state should be operating, but this is where we are. So Attorney Del Campo, agree what you said?
Yes, Your Honor. In November, this was considered by the committee. Judges Albus, Bellis, and Diana had submitted their comments to you. They had gone to the advisory committee on e-filing, and after discussion with that committee, the consensus was that this was, they were opposed to doing this. The committee then wanted the views of some of the clerks, or the clerks surveyed, which is basically what court operations has done, and they've presented their additional comments to the committee for this meeting.
I appreciate that. Given the fact that the number of files is diminishing and the amount of time that would be necessary to try to implement this type of proposal for a ever diminishing volume of cases, I suggest that we take no further action on this item and table it. Is there a motion to do so?
So moved.
Is there a second?
I'll second.
Is there any discussion? If there's no discussion, all in favor of tabling this item, please raise your hand. Opposed? I don't see any opposition, so that'll be noted as unanimous. The next item is the proposal 2023-019, proposal to amend practice book section 30A-5. This is a proposal that has been sent to us by Judge Wilkerson Brilliant, Attorney Del Campo. Actually, let me just say first, before we get into this, this is the first of, I think, 4 proposals that we have had forwarded to us by a judge. And I just wanted to put something out there for the committee's consideration. We can't do this obviously with respect to proposals from others, but when we are receiving proposals from within the branch, I think it might be a good idea that if we ask Attorney Del Campo to share those proposals with the chief administrative judge of the relevant division first, so that when it comes to us, we have not only the proposal itself, but at least the initial impressions from the chief administrative judge, because as will become clear with these next 4 items, all 4 of them are going to have to go to the chief administrative judge of juvenile anyway, along with other stakeholders. But at least at this initial stage, if internally the proposal was shared with the chief administrative judge of that division first, it will help streamline, I think, the process a little bit. I don't know how members of the committee feel about that concept, though. So let's put that out there first.
I'm in agreement with that.
Is there any contrary view? If not, Attorney Del Campo, will that be a big imposition on you in the future?
No, Your Honor, and I know that Judge Wynn O'Dowd is on the at the meeting as well, and it was clear that I did have a correspondence with her to understand that she did have these, but that there would be a committee needed to be put together to review them.
And again, not with respect to the merits of these proposals at all, but whether it's from judges, whether it's from court operations, wherever the proposal initiates from within the branch, I think we should have at least the initial input of the CAJ when it's first presented to us. It's not outcome determinative, but it would at least streamline some of this. So having said that, is Judge Wynn O'Dowd available?
I'm here.
On this first item, I don't, and forgive me, is Judge Wilkerson Brilliant on as well? Okay, since this is our,
I'm here.
oh,
There's
okay.
no-
Doing this on a phone is not.
Justice McDonald, thank you.
Okay, Judge Wilkerson Brilliant, understanding that this will have to probably go out to the Chief State's Attorney's Office, the public defenders, and Judge Winnow Dowd, I just wanted to give you an opportunity to preface that referral with any initial comments you'd care to provide to the committee.
Okay, thank you, Justice McDonald. So I did send the proposals to Judge Wynn. She's familiar with them. And I included in the letters to you, Justice McDonald, all of the explanations and the basis for the proposals. They have been vetted through CSSD. I worked with Catherine Foley-Guy as well as Tracy Duran. So they've been vetted there, but I believe they have not gone to the State's Attorney and Public Defender's Office. And I know Judge Wynn probably, has some input as well, and she has had them, and she just is in the process of reviewing them all. Thank you.
Thank you. So other than the referrals I just mentioned, can any members of the committee think of any other individuals who should be asked for their input before we consider this matter? If not, then Attorney Del Campo, forgive me, do we have a meeting in January or no?
Yes, Your Honor. January 22nd.
Do folks think that's enough time? Judge Chaplin.
Thank you. Judge Wilkerson Brilliant mentioned that she had spoken with CSSD representatives, and I'm not sure if they have an official position on it yet, or maybe they should be addressed as well for an official position for the next meeting to make sure that all of our I's are dotted and T's are crossed.
I appreciate that. That's a great suggestion. Okay, with that understanding, my IT support group is back, so I'm moving again from my chair. With that understanding, we'll pass this item. Do people think that waiting until January is sufficient time for input, or should we ask that this go on to our February meeting? Hearing no input, let's see if we can get that back onto our agenda with the comments by our next meeting in January. The next item is another proposal to amend practice book section 30A-8. I'll turn it over again to Judge Wilkerson Brilliant.
Yes, thank you, Justice McDonald. Again, I submitted a letter explaining the basis for 30A-8. It has been vetted through CSSD, Catherine Foley-Guy, as well as Tracy Duran. And they had asked me to champion that proposal as well. Just to respond to Judge Chaplin's comment, both Catherine Foley-Guy of CSSD and Tracy Duran asked that I submit these proposals. So they and I have gone back and forth with the revisions on this one, 30A-8, as well as the previous one, 30A-5. And just to expedite it, it's the same with 26-1, but I know we're not there yet in 31A-14, but thank you.
Okay, so I think I didn't lose anything in translation as I was moving around my office. With that understanding, I think these would be referred out to the same four stakeholders. Is there any other input from members of the committee on that item? If not, we'll shoot for the January meeting for that as well. Judge Wilkerson Brilliant on the next item, 2023-021, related to
I think Judge Pratt's had her hand up.
Only, thank you, Barry, just to say that
Thank you.
because there's multiple proposals, I'm not sure that the January 22nd might be enough time because they're all kind of connected, and I think they all hit different parts of juvenile that I think maybe the February meeting might make more sense.
I can't disagree with that, other than the fact that March is our last meeting, I believe. Is that correct, Attorney Del Campo?
Yes.
Before the public hearing?
Yes, Your Honor.
So, I mean, obviously, we'll do whatever members of the committee want to do. Do you want to just push it off until February? Or do you want to try to keep it on a short leash?
I think
Is it
they're
make-
all fairly, I think they're all fairly interconnected. So I think that, and I'll defer to Judge Nguyen O'Dowd to, with respect to timing for her ability. I know she's got a lot on her plate, but it seems to me that they're not terribly complicated as far as what the suggested proposals are. So if we can have comment back by January 22nd, I think that would be helpful. Just to see if we can, if we're going to request additional information, then at least we have one more meeting before we have to go to our final meeting.
Thank you. Judge Armato, did you have something you wanted to share?
Well, I thought if I put them on for January, and if they need more time, we can always move it to February.
That was my thinking as well. Okay. So maybe we can just do this and for both the next two, for practice book section 31-14 and 2023-022 as well. Is that acceptable to the committee?
Yes.
Okay, so we won't take them up individually. Finally, 2023-023, a proposal to adopt a new rule which would require the state to provide detailed pretrial notice of an intent to present prior uncharged sexual misconduct. And this is a proposal that has been sent to us by Attorney Dina Fisher. I have to say I'm not surprised we're receiving the proposal, given the fact that it was a case that was it dealt with a case that was implicated by a case that we recently heard on the Supreme Court. I do see that Attorney Fisher is joining us, and with the understanding that we're going to have to send this proposal out to several stakeholders, I'm happy to have her here and to provide any initial comments to the committee that she'd care to share with the committee.
Thank you, Justice McDonald. Yes, I represented the defendant in a case recently decided by the Supreme Court, State v. Samuel Yu. And in that case, argued that the absence of a rule requiring specific notice by the state of an intention to use uncharged misconduct, sexual misconduct, as propensity evidence prejudiced the defendant. Now, in that case, the facts didn't support the claim, but Justice Ecker wrote a concurrence, and in that concurrence urged the adoption of a new rule, which I'm asking the committee to consider here, that would mirror the federal rule. And in the federal courts, there is a very clear and specific rule that at least 15 days prior to a trial, the prosecution must provide the defendant with either a summary of witness statements or witness statements or a summary of what their testimony is going to be. And that is the federal rule with respect to sexual misconduct, uncharged sexual misconduct, but also even with respect to other evidence to be used in some way with respect to uncharged misconduct. Now, Connecticut is in the minority of states that doesn't have any kind of specific rule that would require this kind of information of the state. And I believe that it is necessary to balance the field, that there should be such a rule that does give defendants the opportunity to know what kind of testimony is going to be coming. Justice Ecker referred to a Fordham Law Review article in Winkleread, 56 Fordham Law Review 247, I think. And Justice in the article, Judge Mr. Winkleread made an interesting point, which which is that such a rule assists the judiciary as well as the defendants, and that it would assist judges in being able to rule on the admissibility of this kind of evidence earlier and perhaps with more information, but it also then, of course, helps the defendant to object successfully to this kind of evidence in advance of trial, and of course to rebut it. So for those and many other reasons, I do urge the committee to consider this new rule.
I appreciate that. Are there any questions for Attorney Fisher? If not, full disclosure, I joined the concurring opinion by Justice Ecker. The majority didn't address the issue at all, obviously, because it wasn't presented in that form to the court. I would urge members of the committee, if you have time, to read both the majority opinion and the concurring opinion in the next month or so, if time permits in your schedules. In the meantime, I would recommend that we forward this proposal to the Chief State's Attorney, to the Chief Public Defender, to the Criminal Defense Lawyers Association, and to the Chief Administrative Judge for the Criminal Division for their input. And again, shooting for January if possible. But are there any other stakeholders members of the committee can think of that should be solicited for their comments on this proposal? Judge Armada.
Is there the Connecticut Defense Lawyers Association or a Criminal Defense Lawyers Association?
Yeah, I think I mentioned that, yes.
Okay. And anybody in the CBA?
Is there a separate CBA criminal section? Yeah, I didn't think so. Okay, any other stakeholder that anybody can think of?
Perhaps the sex assault victims advocate. Maybe.
You know, that's a and probably the victim advocate. I apologize. That's a great suggestion, Judge Chaplin. Any other suggestions? If not, let's shoot for that for January as well. Is there any other matters that have to come before the committee today? If not, I want to apologize again for my tardiness and for my technological problems. And with that, I will accept a motion to adjourn.
So moved.
It's been moved. Is there a second?
Second.
It's been seconded. All in favor, please raise your hand. With my gratitude and apologies, we stand adjourned. Thanks very much.
Thank you, everybody.